not a fan of this, but I was hoping we could call the perfection first. I have a
The what?
The perfection case.
Yeah, no problem.
Thank you.
Okay. Okay, all right, so it's a little out of order, but we're gonna take Orle Palacio.
He's in Paul Ryan, Your Honor.
Okay, I don't see him, we'll wait for him.
I was just talking to him, so he should be there.
Sure, he's there.
Right here, Paul Ryan.
Okay, Mr. Palacio, we're back again today.
Your Honor, the state has provided both the court and defense counsel with a supplemental probable cause, well, a new PC affidavit that was prepared by Detective Spiller. Your Honor, Detective Spiller is present in court in case you have any questions, with a new charge of unlawful sexual activity with a person 16 or 17 years of age by a person over the age of 24. That is a second-degree felony, and I believe the allegations would support probable cause for that charge.
Okay, I do find probable cause on that charge.
Your Honor, we have family members here. If you folks would come forward, please, and take a step by the podium.
Okay.
Your Honor, present here this afternoon in court is Mr. Palacio's mother, his sister, and his girlfriend.
Okay.
And they have indicated to me that they would be able to come up with a bond around the area of $20,000. And considering that Mr. Palacio has lived here in the community all of his life and has no prior criminal history and is willing to abide by what other terms and conditions this court would consider applying to bonds, such as not returning to the massage parlor, not engaging in any type of massage even though he has a license, and if the court, and of course no contact with the victim in the case either. My position would be that a $20,000 bond is more than sufficient to ensure his return to court.
State?
Your Honor, as far as specific bond amount, I'll leave in the court's discretion. I would like to advise the court, if I could proffer, I spoke with Detective Spiller. The alleged victim's family has great concerns. These are obviously very serious allegations. I also have, when the court is prepared to issue a no-contact order, I have the alleged victim's initials.
Yes, we don't need to be putting her name on the
No,
record, I would agree.
Put her name on the
Yeah,
probable cause
that's why I got
affidavit.
the initials from the detective.
I'm fully sympathetic with the family's position in this case, Judge. I understand. At the same time, I think the court has to take into consideration the fact that Mr. Palacio has very, very strong ties to the community. I'd advise the court that
Ties to the community.
he can advise you of that. He's been living here all his life, Judge. He owns his own business, which obviously at this point he will not be able to return to. He has a place to stay. Who is he going to be staying with? He's going to be living with his mother. And if you want to hear from the family, Judge, they're more than willing to address the court as to their feelings about this matter, not about the facts of the case, obviously, but about their feelings toward Mr. Palacio and his ability to be able to comply with whatever conditions this court would consider applying to the bond. But from what I understand,
Listen to whatever, if they're here and they want to talk, that's fine.
is there anything you ladies would like to say about Mr. Palacio?
He's a great brother. He's a great father. He's a great person.
Who are
he's
you?
A good sister. His sister.
Would you state your name?
Anna.
Adriana what?
Hitter. He's a
Okay.
great person, a hard worker. He's an amazing person.
Anybody who knows him always speaks very highly of him.
And what is your name, ma'am?
My name is
State your name.
Kimberly Cure.
Okay.
She is very nice to him, very nice.
And what is your name, ma'am?
Maria Elena Palacio.
Okay, all right. Certainly I'm not, I'm just going off of what the probable cause affidavit says. And it appears, Mr. Palacio, that you have, well, I've read the affidavit, and as I said, the facts do support a charge, and the charge state changed. And I do find probable cause as to a sexual battery on a female older than 12 but less than 18.
It's actually sexual activity, Judge.
I'm sorry, sexual activity. And the allegations are that you owned a massage parlor called Massage and Stretch, and that you performed sexual acts on a minor during the massage. Very serious allegations. As a result, I'm going to set your bond at $50,000. I'm also going to order that you have no contact with the victim, whose initials are, I know you just gave it to me.
Listen.
Oh, LB. No contact. You cannot return to your business of, you cannot massage, use your license to massage people. You cannot, certainly no one under the age of 18, but at this point, nobody. And you cannot return to your massage stretch business. Is there any other
I'm satisfied with those release conditions.
add to that? Okay. All right, do you understand, sir?
Yes, ma'am.
Okay.
Yes, ma'am.
I'll give you her extension.
All right, the next case is Christina Casado.
She's in North Broward.
Her DVs? Got it.
Okay, this is, you're charged with battery, domestic violence. I do find probable cause. I'm going to, do you have any input as to the bond?
I
Is
see-
there any priors?
I see no criminal history, Judge.
All right, I'm gonna set the bond.
Judge, before you do, Ms. Casado has no prior criminal history. Unfortunately, she does not have very strong ties to South Florida. She came down here with the alleged victim in the case from New York. She has been working for the last 6 months in retail at Bloomingdale's, and from what she indicates to me, the alleged victim in the case can stay somewhere else, and she could stay at the address in Jackson Street. But she doesn't have any real financial wherewithal to post a bond at this time. I would ask the court to consider a low bond on Ms. Casado, and perhaps in lieu of a higher monetary amount, supervise her under pretrial release.
Okay, I will set the bond at $500, and the pretrial release. And no victim contact. You understand, you can't contact Tony Filippone by text, email, conversation, drive by where he's staying, and nothing. No contact. You understand that?
Yes.
Nothing on the internet, no social media, okay? Yes. Or the lowest level. Okay. No GPS. Okay. Jeffrey Bernard Askew.
He's also in North Broward.
Sir, you're charged with domestic violence, battery, resisting without violence. I do find probable cause. Are there priors? Just totally keep doing that.
They are, Judge.
Well, you know, I feel like I'm in good company because the chief, no, not the chief, one of the Supreme Court justices, I
Yeah,
forgot,
yeah.
United States Supreme Court, Justice Roberts, maybe? His phone went off.
Sure, if someone's it, yeah.
On the bench, but this isn't going off. It's just Siri spontaneously answering me.
2015
Interesting.
burglary of a dwelling and grand theft. 2011 possession of cocaine. 2004 delivery of cocaine. He had a battery in 01. Grand thefts in the mid 80s.
Okay. Sir, I'm gonna set your bond. at-
Judge, if I may.
Okay.
Mr. Askew he's 56 years old. He's been living here in Broward County for the last 50 years, more than 50 years. He's been staying in the same place, the same residence, for the last 4 years. He has no reason to have any kind of contact with the victim in the case. He's had the same job as a maintenance individual at Richard's Motel for the past 5 years, so he's gainfully employed. He believes his niece can post a bond for him, and he has money that he can use to help bond himself out, but it's not excessive amount of money.
I was gonna set the bond at $1,000 on count one and, 250 on count two, okay? And no contact with the victim, Francis Louise Sturgis Alicia. Do you understand that? No contact with her. Sir?
Yes,
Okay.
I understand.
Okay. This is the last one. I didn't send it. Thank you. There you go. All right, Elliot Davis.
Mr. Davis is here, President Main Judge. He declined to serve as public defender.
All right. Charged with domestic violence, battery. You also have a violation of probation on a traffic criminal matter. So you do find probable cause. And your bond, well, you have a $4,000 bond on the misdemeanor probation. And I'm going to set a $1,000 bond on the domestic violence. And no victim contact. So no contact with Rachel Ashley Carter. You understand that, sir?
Yes,
No,
ma'am.
you can't contact her in any way. Social media, phone calls, texting, emails, okay?
Okay, we got children together. How that's supposed to work?
You have children together?
Yeah,
Okay, do you live together?
yeah.
All right, well, you're gonna need the police to bring you over there if you need to pick up anything. And if you wanna see your children, you also need a third party to arrange that, okay?
Okay.
Shannon Lynn Galloway.
She's in North Broward, Your Honor.
Yeah, man. Go outside when you're done. We'll take you back as soon as we get a couple people.
They're bringing her back? Yeah. Christopher Barker. Monty.
Judge, I've been advised Mr. Barker bonded.
Okay, great. DJ Maisonette.
I've been advised he bonded.
Sean Tyler Flowers.
Mr. Flowers is here, President Main Judge. Come on up, Mr. Flowers. Judge, I've been advised by Mr. Flowers he wishes to resolve his case.
All right, sir. You're charged with loitering or prowling. State to
The only thing I see was a Berg dwelling that was declined last year. I don't know if he has anything else.
All right, sir. You raise your right hand. You swear or affirm that everything you'll tell me today will be the truth.
Yes.
All right, you put your hand down. Are you pleading guilty or no contest?
What did you say, ma'am?
Are you pleading guilty or no contest?
No contest.
Okay. And has anybody forced you or made a promise to you to take this plea today?
No.
Are you under the influence of alcohol, drugs, or medication?
No, ma'am.
Understand, if you're not a U.S. citizen, taking this plea may result in deportation.
Yes, ma'am.
Okay. Now, you're giving up your right to go to trial. You understand that?
Yes, ma'am.
And you're also giving up your right to be represented by an attorney to litigate your matter.
Yes, ma'am.
Okay. All right. I'm going to find that your plea is knowing and voluntary. There is a factual basis pursuant to the sworn affidavit. It's going to be a withhold adjudication and court costs and judicial notice of time served. 90 days to pay the court costs, sir.
What happens?
90 days to pay the court costs.
Thank you.
Brandon Genadis,
Mr. Genidis, come on up, please.
sir, you're charged with loitering and prowling. I do find probable cause. Are there any priors?
Hold on. I'm not showing,
Okay.
no Broward priors, I know that, I
Right,
can see
sir,
that.
the bond is set at $100.
Judge, I believe Mr. Gendis is also seeking to see if Your Honor would consider resolving it today for withhold judicial notice of time served.
Okay, you want to do that, sir?
Yes.
All right, can you raise your right hand? Swear or affirm everything you'll tell me today will be the truth.
Yes.
Are you playing guilty or no contest?
No contest.
Anybody force you or make a promise to you to take this plea?
No.
Are you under the influence of alcohol, drugs, or medication?
No.
Okay, and you understand you're giving up your right to go to trial
Yes.
and your right to have an attorney litigate your matter? Yes? Okay. I'm going to find your plea knowing and voluntary. There is a factual basis based on the sworn affidavit. It's a withhold adjudication, court costs, 90 days to pay, and judicial notice of time served. Sir, don't go back to that location, okay? Stay away from there.
Yes, ma'am.
Deontay Lenton.
Mr. Lenson's here present, Judge. He's,
All right. Charge of possession of cannabis and loitering or prowling. There is probable cause. The cannabis count, there's a bond of $100. Loitering will be $100 as well.
Judge, considering this is a nonviolent offense, the possession of cannabis, would you consider an ROR, Mr. Lenton, if the state can verify he has no prior offenses?
Okay.
He's only been 18 a couple months. I don't know if I don't have if he has juvenile priors in front of me.
All right, sir, I'm going to release you, ROR. Where do you live? Do you live with who do you live with?
My dad. My dad.
Okay. And that's where you're going back to?
Yes.
All right. Stay out of that area where you're loitering, okay? And you're going to get notice of court appearance at your address.
Okay.
You want to make sure you have the right address for him.
5701.
Start out with, say, 5701, is that correct?
Yeah.
Kaushwan Hall.
Make sure when they send you a notice, you come to jail. You come back to court, or else a warrant's going to be issued for your arrest. So you're let go. Go.
Kenny Alexander Barrientos.
Mr. Barrientos, come on up, please.
So we're charged with possession of cannabis, disorderly intoxication, and loitering or prowling. Are you going to be resolving this today, sir?
No, and Mr. Barrientos did advise me this is his first arrest ever. I know there's pre-trial diversion program with the cannabis, so it could potentially be off his record. He's a registered voter.
Sure.
We'd be asking you to consider an ROR as well.
Okay, well, first of all, on counts 1 and 3, I find probable cause. No probable cause on count 2. However, I will. Where do you live, sir?
In Pembroke Pines. My parents.
Your parents. Okay. I'm going to release you, ROR. They will be sending this to your address. Do you still live at 9620? That's the first 4
Yes,
numbers.
ma'am.
Your address. Okay. All right. They'll send you notice. Okay. Make sure you
Yes,
show up
ma'am.
in court. Otherwise, it's going to be KP and they're going to arrest you.
Yes,
Okay.
ma'am. Yeah.
All right. Hal,
Take care of this, okay?
next case
Hal.
is Hal Van
How
Pham.
Pham is here present at main judge? He's going to require a Vietnamese interpreter.
All right, we'll have to reset it.
Try and see what they can do. I called them at the beginning of the docket to see if they could get one.
Okay, if not, tomorrow morning. It takes a while, I know, I've had this before. All right. Well, you can have them sit down. They're not going to be here anytime quickly. All right. Ciron Andrew Anderson.
Mr. Anderson is here present at main judge. He's coming up.
Sir, you're charged with burglary, occupied dwelling, unarmed, and a grand theft.
Well, Your Honor, there's nothing to add with regards to the probable cause. It's just some information to provide to the court for bond purposes. So
I do find probable cause.
And Your Honor, first, Detective Tortorici, who prepared the probable cause affidavit, is present in court. He has some concerns that he wants to bring to the court's attention.
Good afternoon, Your Honor. I obtained probable cause middle of March 28th for Mr. Anderson. I've been searching for him since. Every address on file for him is no longer valid. He's not living with his cousin in Miami Gardens. He's not living with his sister in Pembroke Pines. So I didn't know where he was staying. Also on March 29th, 2017 at 3:30 in the morning, in reference to Hollywood case number 17040800697, a black male subject entered an unlocked window at the Tide Vacation Resort located on Hollywood Beach at 2800 North Surf Road. The black male subject entered the bedroom where the victims were sleeping, searching through their belongings. The victims were awoken by the suspect. After an altercation where the male victim attempted to stop the suspect at the front door, the suspect was able to flee the scene. My investigation revealed the victims later identified Mr. Anderson as the defendant in that case. Unfortunately, the victims are tourists from Germany, and they returned home 2 days later, so I don't have a case on that one. Also, on
Judge, I have to object. If we're going to have this type of testimony, I was really kind of waiting for a bigger payoff at the end, like, they positively identified him from a photo lineup or whatever, but, he hadn't said that. I think we're here on this particular allegation.
What are we doing here?
Your Honor, if I may, Your Honor.
Go ahead, make your argument.
The reason the detectives bring this information, Your Honor, under the rules of procedure states that the court can consider any information you find relevant. Detective Rossini is just bringing this information to the court if you find it relevant.
Okay, I get that. Now
Now,
what are you asking for?
Your Honor, the state is going to be requesting a $50,000 bond on one pretrial release of the GPS. Additionally, because I believe I have a concern for the community based on Mr. Anderson's priors. His most recent prior, 2007, out of Broward, burglary of an occupied dwelling and grand theft. He was sentenced to 10-year state prison. He was released in 2015. He also has priors that he's been sentenced to prison for 1990, robbery with a firearm or deadly weapon at a date. He was sentenced to 22-year state prison. Robbery with a firearm or deadly weapon, 1987 at a date. He was sentenced to 2 years. 1987, carrying concealed firearm at a date. He was sentenced to 2 years. So he has multiple priors for violence, using a firearm. It looks like he could potentially be PRR qualified in this case since he was just released in 2015, and now he's alleged to go into someone's residence while they're present, putting their safety at greater risk.
Judge, in reference to Mr. Anderson, if you can hear a little bit regarding his background. Judge, he does have family that live in our community, his mother, his aunt. He resides in Miami Gardens. He's hoping that his family can come up with some sort of monetary bond. Financially, though, at this time, he's unemployed. He previously was working for a company called Fox Rentals. He was cleaning cars, only making $10 an hour. He never had any savings accounts or no checking or anything like that. So he has... right, okay. So currently he has no money in his savings account. He owns no property. So his financial resources are very limited, Judge. So we'd also ask you to take that into consideration in determining a reasonable bond on Mr. Anderson's behalf.
Is there anything else Detective?
If I may, Your Honor,
Yeah,
I
sure.
have numerous cases with the same MO.
Well, without that, Judge, I think that that's not relevant,
Okay,
because
is there
the same
anything
MO,
Well,
No, ma'am.
okay, MO, but do you
No,
have
ma'am, all these
lineups
cases
and
have to do with
Did
occupied
anyone
bird.
ID him?
The German tourist back
Okay.
in Germany, Argentinian tourist back in Argentina.
Okay,
Unfortunately,
but they ID'd him.
yes, unfortunately, Mr. Anderson was targeting the motel hotels, knowing of the tourist locations.
I kind of have to object to that speculation as well.
Okay.
And I'm sorry, Judge, the only other,
Understand that
I'm sorry, go ahead,
His
please.
argument, I mean, what he wants to bring to me that must be relevant. You know, I'm not a jury. I mean, I understand the nuances.
And-
Okay,
and
and I
I-
take everything into account, where it's coming from and all that information.
And, Your Honor, I
understand your argument and I appreciate you making it, but I get it.
And I
Okay.
apologize, I meant to bring this up earlier. Just noticing on Mr. Anderson's booking sheet, I'm showing aliases for Tracy Foster, Sarah Smith, a different date of birth on at least two of them. So I
Okay.
have concerns about his future appearance in
All right.
court also.
I find probable cause. I'm gonna set his bond on count 1 at 65,000. Count 2 is 1,000. Okay.
Judge, if we could go back to Mr. Pham, the Vietnamese gentleman. I heard from the jail that he feels confident enough in his own ability to speak English to proceed without the necessity of an interpreter.
All right, Mr. Pham, this is an out-of-state hold. Not really sure what state it is, but what do they send him to, an extradition?
He'll have an extradition hearing in front of Judge Singal.
Okay, so, right now the bond on that is $20,000, okay?
What they say, I don't get them, because they said this one here, they said this one you say.
Okay, I'm gonna repeat myself, sir, listen carefully. This is an out-of-state hold, there's a hold on you from another state. The bond-
Alabama, right?
Okay, and the bond amount is $20,000.
Yes, ma'am.
You're gonna have another hearing in a few days or a week, I'm not sure when they have those hearings, for further information on the extradition, okay? They're gonna send you back to that state.
Okay,
Okay.
Thank you.
I have another question with you, please.
What?
Please. Because this happened, is I already paid $20,000 for the bail bond last month. This happened, that's the second time.
I don't know anything about it, so get in touch with your bondsman, okay? All
I need to
right.
talk to,
You'd have to talk to the bondsman, sir. I can only go by what they said, okay?
And, Your Honor, I apologize. On Mr. Anderson's case, it wasn't addressed specifically. The state's request for GPS, was that granted or denied?
Put it in the thing so we have
Remember
it.
you asking that?
Yeah,
Nobody asked.
Yes,
You can put it
GPS,
over that one, wherever there used to be.
okay? You can add the GPS.
Okay, so you can have it outside.
And 1,000 on the second count. Okay? Manny Simmons?
Mr. Simmons is here present, Judge at Maine. Mr. Simmons is hoping his mother will be able to post his bond, Judge.
All right, this is possession of PVP and a trespass.
I would argue there's no probable cause to determine that this is PvP, Judge.
Was this the one, right, well, what, well, I mean, I can just go by the fact that I know that it says there was no PVP kit, but, he did admit it, and the officer, recognized what it was through training and experience, so I think there is probable cause. So I am gonna find probable cause on count 1, as well as count 2. Are there priors? There's a lot of aliases.
Yes,
All right, go ahead.
no, I was just going to say, Judge, while certainly all were not pled out, I can tell you he's got 19 prior Broward criminal cases.
Okay. Count one, the bond is going to be $5,000. Count two is $250.
Judge, right now he advised me he's not working. He does landscaping whenever his friend calls him up and lets him know there's work. So there's no steady stream of income. Judge, I'd be asking you, he's going to be contacting his mother. Mother is on a limited income. I'd ask you to consider keeping the standard bond in place of the $1,000.
Okay, that's denied. Derek Edwards.
Mr. Edwards, come on up, please.
All right, you need some guidance on this one.
This is another not in custody, Judge. You should have the PC at the end of.
There's no PC.
All right,
Wait, there is.
Okay.
Wait, but nonetheless.
I can print out a copy.
I have it.
Oh, okay.
Defendant entered a fully fenced-in yard, broke the rear window to gain entry. Something about the victim's bed was blocking a window. Climbed in. Stole money. I mean, got all the elements there, but
They also found
really short probable cause.
No, I understand, Your Honor, but there was also, and I would just also note that there was a latent fingerprint was taken
Right.
from the area at the point of entry.
I didn't say it was his. Oh yeah, matched.
Yes.
Okay. All right, I'm gonna find probable cause. Okay, now it was not in custody. Does he have priors?
2016 fleeing and eluding law enforcement and trespass. Does pretrial have anything else on Mr. Edwards?
All right, sir, I'm gonna set your bond at $5,000.
Judge, I know you heard his record. He's 23 years old. He just started employment. He's working at a car wash, making $10 per car that he washes. He lives in Pompano Beach. He's been residing in the same address location his whole entire life with his grandmother. He has no money, no property. We'd be asking you to, we'd be requesting a $2,000 bond on his behalf.
All right, I'll make it $2,500.
Thank you, Judge.
Alexander Macia.
Mr. Macias here, present Judge of Maine.
All right, charged with possession of a controlled substance without a prescription. I do find probable cause. And I'm going to set the bond at $1,000.
Judge, I ask you to consider an ROR for the following reasons. He's 19 years old. He's currently employed. He works at the swap shop at it's called Phone Surgeon. He repairs phones. Besides that, he's also going to school. He goes to ASA Charter. He's a senior. He's going to be graduating this year. He has a 3.0 GPA, and his intention is to start Broward College this fall. This is his first offense ever. He lives with his family. He lives in Lauderhill with his parents. They've been residing in the same location for 6 years. I know you found probable cause, but for mitigation purposes, Judge, in the probable cause affidavit, he was basically a passenger in the vehicle. Down the line, there may be a motion to suppress, but from what the affidavit says, he cooperated with the police. He freely and voluntarily spoke with the police. He gave information. He was cooperative. Based on the overall situation, no priors, strong ties to community, he's a senior going to go to college, and cooperative with law enforcement, we'd be asking you to consider an ROR.
I don't know if Mr. Romero realizes. According to the allegations, the drugs were found in his client's jacket pocket.
He was a passenger. Passengers can't be simply searched. So I believe the cops are going to say he was cooperative.
Okay.
Says he stated.
All right, I'm going to keep the bond at $1,000. Okay? Jamal
Thank you, Judge.
Donald James. Okay.
Thank God.
Alan Caldwell.
Conti?
Conti.
Judge, on this defendant, count 1 and count 3, the KPS was issued, and the office, it's the same exact PC, basically. So we're asking you to find no PC on count 3, because count 3 is count 1.
Right.
He did a KPS, and then he actually saw the guy.
Okay, who are you?
Confinement status.
Oh, okay.
What I'm going to ask the court to do is, and I'll prepare the order, what happened was, the officer prepared, originally when this happened, prepared a report submitted to the state for non-custody. We filed a non-custody. It just so happens that the officer saw Mr. Caldwell, was aware of this original case, and prepared a new PC and arrested it on that, and that was count 1. He's now here on count 3. Your Honor, what I'm going to ask the court to do is set what was the bond set on count 1? 2. I'm going to ask that a $500 bond be set on this. I'll prepare an order RORing him on count 1. The reason being, as Your Honor is aware, the state's going to know info count 1 because we've already filed a charge on count 3.
Right, I have it says capious felony, no bond.
It actually should have been 1,000 pursuant to the not in custody capious.
Okay.
All I'm asking the court to do is he's being held on 2 cases for the same offense. I'm just asking Your Honor to attach the bond to the case that the state's actually going to go forward on, instead of the case that we're going to end up no infoing. Because then he'd be essentially ROR'd on both cases.
And count 2 is a child support issue, right?
That sure.
Okay. Alan, do you understand what what the state is saying?
Yes, sir.
It clears up the confusion we had about how many grand thefts you have. You only have 1, but they charged you twice. So they're going to release you on one of them, and you'll have a $500 bond on the other one. Do you understand?
And I'll prepare an order for the court.
All right.
That's fine.
Yeah, I'll do that, because
Okay.
Sheila, the other way, he would have gotten an ROR on the case that we're going to actually go forward
Is it
on.
possible I can take you off count? I have a slight emergency. I'm in the middle of a murder trial over in front of Judge Vogel. I just wanted to.
Oh, sure, I only have 1 case left, but go
Oh,
ahead.
okay. I'll,
No. Oh, I might have more, if there's more in the docket. What do you have?
Your Honor, I have a matter. It's not on you. I have a motion to quash a capious. I have a client that actually is in your courtrooms.
Oh, okay.
And on Friday, I did not appear. He has a verified written waiver of appearance, so I was appearing for him. He depended on that. And through a screw up at our office, I didn't appear. And so there's a capious.
Okay.
So I have.
This one's in 500.
That's what I have, because I know. Okay. Here, I'll give you all this stuff back. Okay. Sorry, you should have told me I would have to wait. All right, Tommy Thompson.
Conky again?
Your Honor, this is a change of charge. When he first came through, it was burglary of an occupied dwelling. The bond was set at $50,000 by Judge Fry. We have filed a charge. It's treated as a burglary of an unoccupied dwelling, but I can tell you I spoke to a case filer. It's just the state's position to file it as a burglary dwelling. Whether it's an unoccupied or occupied, they're both second-degree felonies. There really is no significant difference. So, Your Honor, I am going to be asking the court to reset the bond at $50,000. He's being held on another burglary of a dwelling at $50,000, and I believe, Brian, is he being held no bond on something?
Yes, he is being held no bond on, I believe, 2 counts of violation of probation.
Okay, so what are you asking for on this one?
Just asking that the original conditions be put back in place.
I'll do that.
It's
Original conditions.
$50,000 on 1, $500 on 2. And does pretrial know, was there a GPS on that also originally? I think there were 500. Oh, it's hold on.
Yeah, I only have 1.
Oh, okay? Then there's nothing on count 2. Sheila, are your records showing that there was pretrial GPS originally on these counts?
No.
Okay.
Not on this,
That's fine. Yeah.
They had sent her that.
Okay, Shannon Galloway. Where's that? Shannon Galloway. Yes, she got away.
North Broward, I think, should.
I remember she walked away and they probably didn't get her, so we'll just reset this for tomorrow.
For the record, I did speak with her attorney, Mr. Kaufman. He was aware that she was going to be on this afternoon's docket, so.
Okay, well, it's just, let me have it again. Sure. All it really is, I guess, ad charges?
I believe so.
All right. right, and it's $1,000 bond on count 1, $25 on count 9. I'm sorry, 8 and 9. Okay, so we're not gonna reset that. I don't have a docket.
Judge, we're here at Maine. We have two last people here at Maine. I don't know if we can address them now.
Who are they?
Come on, Mr. Willie King, come on up. He's on your, he's here for a 30-day ROR motion.
Okay, page 4.
Okay, one moment, Judge. It has been filed, Your Honor.
Okay, that was filed, sir.
Okay. Unfortunately, the motion is denied. You'll be seeing your judge. Good luck, sir. Okay. Yeah. Yes, it was denied. The last person here at Maine, Judge, is Mr. Leslie Spiller. He's on your second look docket. He's been in custody since May 7th, and he's here on a grand theft and uttering a false instrument, a $2,000 bond. He's still in custody. He cannot afford the monetary bond.
So this is a
Second look.
second look.
Second look on a felony, Judge.
All right, are there priors?
I'm not showing any Broward priors. Thank you.
What are the priors?
I'm looking for the picture.
Well, I have this as a grand theft, so.
Now, he does live in Miami with his father, so he does have a valid address. So Your Honor could order a pretrial release, and if they verify his address, he can be released to pretrial. So he'll be supervised, and you'll have to go to court and everything like that. If he doesn't abide by any pretrial rules, he'll be held no bond.
We're looking for priors.
Okay.
I'm sorry? No.
Okay. Put him on recall. Patricia Melee. One more time, Patricia Melee.
All around, Your Honor.
Case state.
I'm checking that right now. Ms. Millay can be ROR, Your Honor.
Okay, we're gonna get ROR on this. They haven't filed the charges yet. But it's still pending case. Okay, Lovisky Johnson.
I'm done.
Okay.
Just one moment, Your Honor.
Mullins.
Has not yet been filed, Judge.
Okay, so it's gonna be on ROR in your case to your case also, sir. So, they're gonna release you, but the case is still pending, okay?
He still has an open VOP case.
What does that mean?
He's not getting out.
Okay.
Your Honor, if I could just, I'm sorry, if I could have one moment, I just want to. Okay, yeah, that's nothing additional from the state.
Okay. Antoine Mullins.
Okay, take your arms out. Take your arm, that one too. Yes. North Broward.
Okay.
Has not been filed, Judge. He's entitled to
Okay,
an
this
ROR.
is an ROR also, sir, but the case is still pending.
Okay.
Jaquela Jones.
All right.
Charges have been filed.
The charges have been filed, okay? Kenold, Michelle,
Judge, it's gonna be an ROR whenever.
okay, Kenold, Michelle is an ROR.
North Broward.
All right, that's an ROR, sir.
Okay, so-
Melvin Stewart, did we did
North
get
Broward.
into it, right?
Yes, yeah.
Okay, North Broward.
And
You gotta go home, okay?
Melvin Stewart. This is an ROR.
ROR, sir. Case still pending now. Christopher Dalzell.
This,
Conti?
Your Honor, our office spoke with the Assistant Public Defender that filed. This was filed in error. As you can see on the docket, his arrest date is April 26th, so we're not within the 30 days. It's not
Okay.
ripe.
So I'm gonna delete that from the docket, sir. Was it filed though?
Hasn't been filed yet, but it's only been like
Time. Okay.
13 days,
The state still has
15
time
days.
to file it. Okay. Tyrone Peterson.
Conti again?
Yeah, this is
Okay. It's the second look.
it's a second look, and I can pull his record.
Go behind him and
What was the bond set? Anybody?
And his record includes.
Well, there was a KPS, so I'm gonna keep it the way it is. Yeah, so I'm not gonna change it. Leslie Spiller.
Clapping.
Regarding Mr. Spiller, 2014 trespass adjudication, 2004 theft adjudication, 2003 possession of cocaine, possession of cocaine in 2003, 2002 possession of cocaine adjudication, 98 possession of cocaine. Does the court want me to continue?
Well, I mean, are they just drug charges after that?
Robbery in 88, possession of a weapon by a convicted Florida felon. In 89, he violated his probation. Possession of cocaine and possession of marijuana.
Okay. So what is this, a second look?
Yes.
Judge, I believe from what I heard, what I was able to pick up actually, the most serious offenses happened in the 80s. Mr. Spiller does, from it seems from his record, has prior drug offenses. Therefore, our defense's position is still the same. We'd be requesting if you would consider a pretrial release and have him reside with his father in Miami if pretrial can verify his address.
State?
Frankly, with his amount of priors, dated and recent, it just doesn't seem to be a good candidate for pretrial, just because it's available.
Okay, I agree with that. What was the bond amount on this?
$1,000?
$2,000.
$2,000?
Fair. Okay,
Yes, Judge. Thank you.
all right. Just leave it the way it is.
Judge, we're here. We're done at Maine.
Okay.
See you tomorrow.
See you tomorrow.
Just got a few
All right, so we have
misdemeanors.
Mary Diaz.
North Broward.
Mary Diaz posted Bravo 6.
Wait a minute. Oh, I skipped pages. Okay, wait.
Mary Diaz bonded.
Yeah, she's county sentence.
Okay.
She'll be released tomorrow.
So we have Tyrone Peterson,
You handle him on the phone. Yeah.
come on. Nathan Pierce.
North Broward.
He was on the felony second look, and this was a capias that he was arrested on when he was arrested on the felony.
Out of my division, I think.
Your Honor, Mr. Pierce, he had one theft that it looks like he got pled out.
When?
Since he was arrested April 25th, I don't know what date specific. He's got an out-of-county hold out of Marion County, a $500 bond for theft. These two thefts are still open, and it looks like he had a possession of PvP that he got placed on probation.
Okay, well, he has an attorney, public defender's office, so, you know, I think it's my division, it's my my public defender. So you can just set it over for next week, on Wednesday at 9:30. Okay? And then you can talk to his lawyer. All right, Michael Love.
Conti?
How you doing, Judge?
Okay.
This was a alleged trespass at the promenade at Coconut Creek. It was alleged trespass at the promenade in Coconut Creek, Judge.
Does he want to resolve it?
Yes, please.
All right. It's going to be, does he have priors?
He does. Let me see if there's anything that the court should be concerned with.
Mostly, does he have a lot of trespass?
That's what I'm checking.
Can we watch the show Moon Turner?
No, he's got a lot of more serious stuff, just not trespass. I mean.
All right, sir, you want to resolve it? It's adjudication, court cost, credit time served.
Done.
Do that? Okay.
Yes, let's do it.
Okay.
Thank
you.
I think that's it.